Members, welcome for attending this meeting of the panel on administration of justice and legal services. We've already formed a quorum, so let's start. We have two items on the agenda today. One is about the Judicial Service Pay Adjustment. The representatives of the administration have submitted a paper to us to propose a salary increase of 5.66% for the judges. So over to you, Ms. Kitty Choi, Director of Administration. Thank you very much for according me this opportunity to introduce to you the deliberations and decision of the Standing Committee on Judicial Salaries and Conditions of Service. Since 2009, the judicial salaries and conditions of service were detached from those of the civil servants in terms of adjustment. Every year, the Chief Executive in Council considered the recommendations of the Independent Standing Committee for pay adjustment. That's an independent body appointed by the Chief Executive. The details are already annexed to the LegCo brief. In May 2008, the adjustment mechanism, as approved by the CE in Council, comprises two parts: a 5-year cycle of adjustment, the last one in 2010, and then the second last one in 2005. In 2010, it was clearly decided that there should be systematic recording of the salaries of judges and judicial officers so as to ascertain the relativity of salaries of the various posts. And that's the 5-year benchmarking study. Another element is the annual pay review. In May 2008, the CE in Council determined a basket of factors comprising 12 items. These are detailed in paragraphs 3 to 16 of the paper. That include responsibility, working conditions, and workload of judges vis-à-vis those of lawyers in private practice, recruitment and retention in the judiciary. And on this particular point, the judiciary indicated to the Standing Committee that there was no recruitment problem, and the establishment can match the existing and forecast workload. And in the basket of factors, retirement ages of judges and judicial officers, as well as their retirement benefits, are taken into account. In particular, those that are applicable to judges and judicial officers and their special duty nature. For example, under the law, there are requirements that restrict judges or judicial officers from serving as practicing barristers and solicitors after their retirement. It also depends on the fringe benefits of the judges and judicial officers. For example, they enjoy pension, housing allowance, etc., etc. At the same time, the overall economic situation of Hong Kong, the financial position of the SARG have to be considered. And also the pay trend survey result of the civil service should also be referred to, as well as the pay level survey results. For 2012-13, altogether 12 factors in this basket were considered. We also bear in mind that there should be judicial independence, and we also consider the position of the judiciary on this pay adjustment. So it's recommended that the pay trend survey overall indicators For the private sector, 6.01% should be considered. But this percentage covers bonus as well as increments. Therefore, eventually, the Standing Committee recommended that for this seed indicator, 0.35% should be deducted. Therefore, ultimately, the CE in Council approved an increase of 5.66%. If today the approval of this panel is obtained, we'll as soon as possible arrange for the proposal to go to the Finance Committee for approval. The expected expenditure incurred will be $16.143 million as detailed in the paper. So much for my presentation. My colleagues and I will be willing to answer members' questions. All right, question time for members. First of all, Ms. Emily Lau. Thank you, Madam Chairman. Chairman, if the judiciary also agrees to the recommendation, I won't have any strong view. But I would like to ask a few questions. First of all, I'd like to ask about paragraph 6 of the paper. There it is said that there are many vacancies in the judiciary. Chairman, this was discussed during the last term of the LegCo. Altogether, there were over 40 vacancies. We were very worried about so many vacancies. But apparently, the Standing Committee was very satisfied with recruitment and retention. So why are there so many vacancies? Why can't we fill them as soon as possible so that we don't need so many deputy judges? Secondly, I'd like to ask about the salaries. For NXC, for the Chief Justice, is over $250,000 per month. Of course, we're always told that this is higher than that of our counterparts. But a secretary enjoys $320,000 of monthly salary. For principal official, over $345,000. CS for administration, $357,000. Well, there's a hierarchy. After the CE, it should be the Chief Justice. But then, his salary is far below that of the CE. I wonder whether Mr. Bernard Chan's committee has studied this. What about the practice in overseas jurisdictions? Well, the status of the Chief Justice is very high, higher than the accountability officials, but then he enjoys a much lower salary. I'd like to thank the honourable member for her question. During the recess of the LegCo, this paper was published. I'd like to update members on the latest figures. That is up to the 31st of March 2012. But I have the latest figure on the 1st of November 2012. Within the establishment, there are 191 judiciary posts. For substantive judges, 154. This precisely indicates that since June 2011, our recruitment exercises are gradually producing results. Apparently, we have 37 vacancies, but according to the information from the judiciary and according to a paper submitted to this panel on the 28th of May this year, no matter how many vacancies there are, well, at present we have 37, 13 posts cannot be filled by substantive judges. Why? If you look at the presiding officers, we only have 7 posts for the magistracies. So although in the establishment with 9 posts, the remaining 2 will not be filled by substantive judges by the judiciary because there are no operational needs. As for the other 11, the number of magistracies is not enough at the moment. Therefore, even if substantive judges are to fill the post, it won't be helpful. So, from 37, you should deduct 13. So, the actual number of vacancies is only 24. If you do a division, you see that the vacancy rate is only 12%, which is much better than that depicted in the paper, because gradually the judiciary is conducting various recruitment exercises. Ms. Lau may ask when these posts can be filled. When the West Kowloon magistracy is completed, the judiciary will gradually increase its manpower. Just now, Ms. Lau said that all along, if there are special needs, the judiciary will, in accordance with the paper submitted on the 28th of May to this panel, deploy deputy judges to handle certain cases. So when Mr. Bernard Chan conducted the review under the Standing Committee, the judiciary was consulted. The Chief Justice and the judiciary told him that the existing establishment is sufficient and the existing level of manpower is sufficient to cope. Starting from 2011, the judiciary has been recruiting manpower. Members will recall that in 2008, the judiciary carried out a large-scale manpower review. At that time, is it 2008? Yes. At that time, there was a net increase of 7 posts of judges. And this year, that is 2012, earlier on, we increased 2 judges for the Lands Tribunal. And earlier this year also, the competition bill was enacted. And I believe that as a result, later, 2 more judges will be added to the judiciary. So, there were post increases and we've not encountered any recruitment difficulties. And the actual strength of the judiciary is ever enhancing. Now, when all recruitment exercises at all levels of the judiciary are completed, the Chief Justice may start another round of overall manpower review. Ms. Choi, Ms. La asked about the salaries of our judges as well as those of the officials in the administration. Apparently, there are discrepancies. Well, Madam Chairman, allow me to say this. These are 2 different mechanisms. Very often, the judiciary reminds us that we have to carefully interpret certain observations.
As for judges' remunerations, that's one issue. When the Judicial Committee reviews their remunerations and terms of employment, such as now, they have looked at the special characteristics of the judiciary, the fringe benefits they enjoy, and as well as the retirement age, etc. And I can make several points concerning this. Now, if you want to compare the judges and bureau secretaries, I think that is not that appropriate. Well, as we all know, for politically appointed officers, they have no security of tenure. However, for judges, depending on the different levels, they all enjoy security of benefits, and some of them retire at 60, 65, or they their employment can be extended up to the age of 70 or 71. As for politically appointed officers, they do not have any housing benefits, and they do not enjoy pension. However, for judges, they enjoy home financing allowance. Some of them can live in government quarters, and they also enjoy all sorts of allowances. For example, education allowances and leave passage allowance. And the bureau secretaries do not have this kind of benefits. In Hong Kong, we have judicial independence. So for the review of the remuneration, it should be independent as well. Well, Madam Chair, I hope that the Judicial Committee can also take reference from overseas experience. For the judges, when their pays are compared with the executive officers, what is the situation like? Because for our politically appointed officers, their pays have been increasing all the time, and our CE has a pay of over $400,000, and that's even higher than that of the U.S. president. So I think this is really inappropriate. For the Chief Justice of the Court of Final Appeal, he should be ranked second in the Hong Kong SARG, but his pay is lower than the political appointees. Now, you are saying that, well, because the judges enjoy high esteem in society, however, nobody respects LC Leung. So I don't think this can be handled today, but I think a review should be conducted. I think we also discussed this before. And for the political appointees, they enjoy pay increase all the time. Well, we do not have security tenure. Anyway, Madam Chair, maybe you should also look at this. Well, so you enjoy all the benefits. I think you should really go back and look at this. Now, the Chief Justice of the Court of Final Appeal, $250,000. As for bureau heads, $320,000. That's outrageous. Can you provide us with the relevant information? Because not many members raised their hands just now, and now Dennis Kwok and Mr. Kwok would like to ask questions. So I think for each member, now we should impose the 5-minute rule that includes both questions and answers. And if you want to ask questions, please raise your hand so that I can calculate the time. So if there are not too many members who would like to ask questions, I would be more relaxed.
I believe it is, of course, of cardinal principle of judicial independence that matters of judicial remuneration, judicial appointment, and judicial promotion should be decided entirely free from any political considerations whatsoever. That the work of the Judicial Committee should be entirely above politics. And that is what we believe to be the most important in deciding matters of judicial remuneration and appointment and promotion, that there should be no political considerations. The legal profession is, of course, very concerned about whether the judiciary is getting sufficient resources, both in terms of the support for judges in conducting their day-to-day caseload, and whether the litigants are getting an efficient and not prolong a waiting time when it comes to cases in the High Court and District Court, and of course the magistracy. The Honourable Ms. Emily Lau has mentioned the issue as stated in paragraph 6 of the paper provided by the administration, i.e. the alarming numbers of vacancies that we have right now in the judiciary. Even with the new numbers as provided by the administration just now, there seems to be still a very high number of vacancies in the judiciary. Speaking from the perspective of legal practitioners, we've noticed that the waiting time in the High Court and the District Court have increased over the years. And as you will see from the Law Society's letter, which has been tabled before us, dated the 30 October 2012, they are also raising the issue of the the number of days which one has to wait before cases are adjudicated in the High Court and the District Court. Now, of course, justice delay is justice denied. And that is a serious concern for not only legal practitioners but members of the public. And we wish that the judiciary, when considering pay and remuneration issues, it should also look at whether the judiciary is obtaining sufficient resources. However, I note from a paper dated March 2012, which is submitted to LegCo this year, that the judiciary administrator seems to think there are sufficient resources at the moment for the judiciary to deal with its current workload. But speaking from the practitioner's point of view, that seems not to be the case. So we understand the administration probably needs to go back to work with the judiciary administrator to understand why they think there are at the moment sufficient resources to deal with the workload. We wish that, Chair, that they would come back with a further report if they can't deal with these questions today on whether there are sufficient resources for the judiciary. We see that in the High Court there are at least 4 to 5 deputy High Court judges being appointed to work in the High Court at the moment, but that is not satisfactory because we can't rely on deputy appointments in the long run. That's not the solution, and that would affect the independence of the judiciary. So those are the basket of considerations which the Civic Party wish that the administration would address, if not in this meeting, but in subsequent panel meetings. Thank you.
Okay, Choi Chu-Chang. Okay, thank you, Madam Chairman, and also thank you, Mr. Kwok's question. I think as I explained to the Honourable Emily Lau just now, the Judiciary Administrator has indicated to us that the manpower situation or the creation of posts has been in the range of being satisfactory. And that talking about resources, I would like to ask Mr. Kwok to view it in totality. In fact, it is a matter of fact that according to the Judiciary Administrator's Controlling Officer's report, indeed, the waiting time for certain courts, such as the High Court, insofar as the civil cases are concerned, and also insofar as the Court of First Instance for the criminal cases are concerned, indeed, the target waiting time has been exceeded. But I think it should also be viewed in its totality that insofar as the CFA is concerned, and also the Court of Appeal cases, these, and also the family courts, the target waiting times are met. And not that the JA is not aware of the problem concerning the waiting time, but I would like to emphasize that according to JA, it is not a matter of insufficient posts, but rather it is due to the short-term manpower rejuggling, while we have judges retiring from the bench, or it is waiting for the permanent judges to come into posts. And that is why the JA has been relying on the long-standing arrangements whereby they hire deputy registrars from the private sector. So I can relay Mr. Kwok's concern to the Chief Judge of the CFA concerning the manpower situation. But as far as the JA is concerned, they have already submitted a comprehensive paper this May to this panel explaining the overall manpower and also recruitment situation, as well as the waiting time of the various layers of courts. Thank you, Madam Chair.
Well, I would like to tell members that on the 30th of October, we got this letter from the Law Society. We have actually invited them to come to this meeting. However, they do not have the time to attend this meeting. Well, as Mr. Kwok said just now, in the letter, yes, this has been said. Well, actually, in our profession, we all know that the waiting time at courts has been very long. So is it because there is a shortage of resources in the judiciary? I don't think it's just a short-term problem. Maybe other members would like to follow up on this issue as well. However, it gives the public the impression that the resources for the judiciary are not enough. And that's why the judiciary cannot tackle its present workload. The next member who would like to ask a question is Mr. Kokaki. Madam Chair, in the paper, it is recommended that the JJO's remuneration be increased by 5.66%. I do not object to that. I actually support that. But I have two questions. Now, as outlined in the Law Society's letter in 2009, the waiting time was 179. That was the civil fixture. That's in the civil fixture list, and then it increased to 215 in 2010. So that cannot be regarded as an improvement. So is it related to the shortage of manpower in the judiciary? I have two questions, and actually one question was asked by Ms. Emily Lau. That's about the structure. Now we all know that for the past judges, well, before we had the accountability system, the judges' pay were pegged to that of the civil service, so they were comparable. However, after the implementation of the of the accountability system, where we all understand that they are actually not accountable, so no matter how their performance are, they can still remain in their positions. Now, for this pay level, actually, it cannot reflect the importance of the JJOs, at least in the establishment of the government. And I would like to ask Ms. Choi these questions. Now, this is a structural problem. I think, well, Mr. Bernard Chan is the chairman of the Judicial Committee. I think he cannot do this review because this is about a structural change. That is for the JJOs. Can the pays be aligned with those of the heads of bureaus? And when will that review be done? And does the government intend to do such a review? And also for the appellant courts and the high courts, there are a lot of vacancies. The government is telling us that over the past few years, there has been no overseas recruitment. Now, if we want to maintain the efficiency of our courts and if we want enough manpower in our judiciary, I think for maybe we should recruit judges from other Commonwealth countries. We have seen some outstanding judges from other Commonwealth countries in the past. So at this moment, maybe you should try to identify experienced judges from other countries. And why are you not doing that?
We should not leave so many vacancies there without going overseas to do recruitment. Ms. Choi, thank you, Mr. Kwok, for your question. Let me say this about vacancies. Of course, my reply is based on the information provided by the judiciary. I think the most accurate method to assess whether or not there are recruitment problems is that at the CJ and other judges level, recruitment exercises have been underway since June 2011. According to the information given by the judiciary, they have not encountered any recruitment problems. I cannot say on behalf of the judiciary whether or not we should now go overseas to recruit JJOs. But I believe the Chief Justice and the judiciary will serve as the first gatekeepers, and they know the situation best. Mr. Kwok mentioned the structural problem. In my opening remarks, I also said that Mr. Bernard Chan's Standing Committee, apart from conducting an annual review, conducts a large-scale benchmarking study every 5 years. In 2008, the CE in Council decided that the judiciary salaries and conditions of service should be depict from those of the civil service, and relativity with legal practitioners in the private sector should be referred to, and the long-term trends should also be examined. And nothing was mentioned about the political appointees. As for the benchmark study in 2010, something was very interesting. The 75th percentile was examined. The JJOs in our judiciary, at the magistracy level, at the district court level, compare favorably with their counterparts in the private sector. Whether or not the discrepancy should be reduced or further enlarged will be a subject of the 5-year review cycle. For those judges serving 15 to 24 years, 47% instead of 42% of the private sector counterparts are enjoying lower salaries and conditions of service than these JJOs. And the benchmarking study of that year referred to the relativity pattern and did not observe any fixed pattern. And it was observed that barristers are more interested in deputy judge posts than solicitors. Moreover, the observation in that year was that if the salaries of the judiciary are to be directly compared with those of their counterparts in the private sector, the administration have to be very careful. And the basket of factors formulated in 2008 already referred to these observations. I hope that I've responded to Dr. Kwakaki's questions. You said that in 2008 there was this benchmarking study. No, it's 2010. So the next benchmark study will be carried out in 2015. Of course, we have to respect the observations of the Chief Justice. But if you look at the figures provided by the Law Society, then you have to be accountable to the public. Because the number of cases waiting to be listed is ever rising from year to year. The fairness of the judiciary is doubted as a result. I think both the judiciary and the administration will look at these figures, and you have to handle them. And just now I asked a question about the Court of Appeal and the Court of First Instance, which have more senior judges. And the discrepancies between their salaries and their counterparts in the private sector are larger. Now, when these discrepancies grow, you really have to handle the problem. I don't know when you deem this urgent. As members of the public, we are really very worried about these rising figures of cases waiting to be listed for hearing. Well, I left out one point. In the benchmark study in 2010, one thing was crucial. For those interviewees who are interested in the posts of judges, they all said that salaries were not their key concern. And the judiciary also noted that for the Court of First Instance, for both civil and criminal cases, the performance pledges were actually met. And every year, after a recruitment exercise, when new judges assume office, their first priority was to clear the backlogs, and criminal cases were always given priority. So when all recruited judges and judicial officers are in post, I believe there will be a change for the better. Well, Ms. Choi, long waiting time for listing is really a public concern. I think you have to follow up on this. There's a loud voice in the public that complains about the long waiting time for listing. And just now, Assembly Lau asked for better reference materials. We'll distribute them to members in due course. Mr. Porte? Thank you, Madam Chairman. I have 3 groups of questions. The first group is about the waiting time for listing. Apart from the general public, the profession itself is also very concerned. Apparently, the waiting time is becoming longer and longer. How is this related to the number of JJOs? 2 to 3 years ago, we had the civil service reform. Theoretically, case management for civil cases should have improved. But looking at these figures, apparently, instead of improvement, there was deterioration. What are the genuine reasons for the long waiting time? What are the factors involved? That's question 1. Now, looking at the recommendations this time, our colleagues were questioning the discrepancies between the salaries of JJOs and those of their counterparts in the administration, namely the bureau directors and undersecretaries. Now, if you refer to 6 common law jurisdictions, Australia, New Zealand, Singapore, Canada, as detailed in paragraph 16, or paragraph 12, some of the judges in these jurisdictions had their salaries frozen, and sometimes discrepancies between the public and private sectors had to be reduced. The overall discrepancy in 2012 is 0.23% only. So we have fared better than our counterparts, common law counterparts, rather than faring worse than them. As regards recruiting judges from overseas, we have to be very careful. First of all, local barristers would like to have more opportunities to join the judiciary and get promoted within it. And if you look at the judges of other common law jurisdictions, if you look at their languages, their culture, etc., you see that overseas judges may not be able to grasp the local situation immediately when they conduct trials or preside at trials, particularly for hearings at first instance. Queries may be raised. Now, we very often mentioned the introduction of overseas professionals from overseas. Well, for Dr. Kwakaki in particular, if we talk about introducing overseas doctors into Hong Kong, he might think otherwise. As for the retirement age of judges, at the moment it is 65 for our judges, but many judges at the age of 65 are still very healthy and competent, like Mr. Justice Bokhari. So can we lift the retirement age of judges? When many people are worried about old age allowance, etc., many people mentioned aging. So if we can raise the retirement age of the working population of Hong Kong, it may be good. Ms. Choi? Well, I think I've forgotten his second question. I think honourable members are very concerned about the waiting time. I think the best way for me to address members' concern in this regard is to provide some information provided by the judiciary. In the paper submitted to the panel on the 28th of May, it is mentioned that the Chief Justice understands that at the district court, magistracies, etc., the waiting time requirement is met. But in the High Court and in the Court of First Instance, the waiting time was indeed a bit too long. Mr. Porte asked about the cause. It's because cases became more complicated and the waiting time, the hearing time, etc., were lengthened. And very often the listing time or the waiting time for listing was also lengthened. Besides, many judges retired. Some judges were promoted. So at those two levels of the judiciary, there were manpower constraints. Ever since the 13th of December 2011, all judicial posts in the Court of Appeal were filled by substantive judges. And in the past year or so, the backlog of cases has already been handled gradually. As I said, the Chief Judge of the High Court has accorded priority to appeal cases for criminal cases. So the program is already underway. As regards the Court of First Instance, in 2011, the waiting time was prolonged, not because of inadequate judicial posts. I mentioned this when I answered the first question. It's not because of inadequate judicial posts. There's only a temporary shortage, and the work of the Court of First Instance was very smooth. In order to address transitional demands, the judiciary has always recruited deputy judges from within and without the judiciary. Now, this is to answer Mr. Porte's question about waiting time. His third question is about retirement age. I have to say that in the Court of Final Appeal, the High Court and the District Court, there is a statutory retirement age for judges. For the High Court, it's 65 years old. But judges can have their tenure extended twice, 3 years every time, until 71 years old. So the arrangement is very flexible. For the High Court, the statutory retirement age is 65 years old. But again, that can be extended to 71 years old. For those judges appointed after 1987, the statutory retirement age is 65 years old. For judiciary administrator and deputy judiciary administrator, the retirement age is 65, but if necessary, that can also be extended to 70. So it's not like civil servants who have to retire by 60 years old. Mr. Porte, I forgot your second question. Is about the salaries of other common law jurisdictions. Do you have information about other common law jurisdictions? What about the salaries for judges?
Well, maybe after the meeting, I'll try to find whether we have that information. Now, when the Judicial Committee conducted this review, it has taken reference from other jurisdictions. That is, from 2012 to 2013 was their pay adjustment mechanism, and it's discovered that there has not been much changes. For example, the UK, the US, Australia, Canada, New Zealand, they mainly looked at the overall economic situation of their own country. In the past year, they tended to be more prudent. Well, some of these jurisdictions have frozen the pay, some had deferred pay adjustment, etc. Now, for the retirement age, it's said that it can be adjusted quite flexibly. But is this really done, or are judges retiring at the statutory normal retirement age? Well, I do not have the reference information in hand right now. I'll refer the question to the judiciary. Ms. Emily Lau and Mr. Porchi both hope that you can make a comparison with overseas countries, and also a comparison should also be conducted with that of the political appointees. Now, we have several members who would like to ask questions. Please stick to the 5 minutes rule. Mr. Lang Sing, Mr. Wong Yukman, and Mr. Ron Tong. Thank you, Chairman. Just now, we mentioned paragraph 5, and that's about the retirement age. And retirement is the main reason for the wastage among JJOs. As for the Law Society's letter, it also says that in the coming 2 years, many JJOs will be retiring, and this will be a major problem. So I want to know the administration's perspective. Now, retirement is the main source of wastage among JJOs, so that would be very stable. So the judges would not retire because of low pay or poor fringe benefits. So almost all of them would only retire at the retirement age. So that's why retirement is the main source of wastage. And also in paragraph 8, it is said that when it comes to recruitment, most of the people think that the remuneration package is satisfactory. So it seems that we will be able to attract talents, and there is no urgent need to increase the Chief Justice pay to align it with the Bureau Secretaries, because, well, the Chief Justice does not have to come to the LegCo to be questioned by us. So my question is not about whether the pay is appropriate. And paragraph 3 says that there should not be a comparison of pays between legal practitioners in private sector and the JJOs. So this comparison should not be made. So I don't think a comparison should be made with that of the Bureau Secretaries or political appointees. Now, if we are too generous, then the taxpayers would think that our standards are very confusing. Well, it seems that the judges are not unhappy themselves. Then why do we take the initiative to increase their salaries? Because the money comes from the taxpayers. So maybe you should really think twice. Is there such an urgent need to increase the JJO's salaries? And now it is said that the retirement is the main source of wastage among JJOs. So how about trainings and succession plans in the judiciary? And the Law Society thinks that in the coming 2 years, there will be more judges retiring. And also in Annex E, there are some data. It seems that for 2010 and 2011, the case load in local courts has gone down. Well, when it's compared with the previous year, there has been a drop by 6%. So do we really do not have enough manpower, or has there been a drop in caseload? Now, if we really do not have manpower, and that's why they are handling less cases, maybe we should adopt a more scientific approach. Thank you, Mr. Ng, for your questions. For Mr. Ng's first questions, that is for the Chief Justice and the Judiciary, they would look at manpower arrangements in the long term, and actually retirement is indeed the main source of wastage. So when it comes to manpower assessment and projection, the judiciary has done the studies in those areas. And in 2008, a comprehensive manpower review was conducted, and 7 judges' posts were added. And earlier this year, we created 2 posts in the Lands Tribunal. So after increasing such posts and after rounds of recruitment, as I repeatedly said just now, ever since June 2011, there have been a number of recruitments. And actually, before June 2011, there were rounds of recruitment as well. And the Chief Justice said that towards the end of this year, after this round of recruitment, then in the coming year, it may be an appropriate time to conduct a comprehensive review concerning judge manpower. So as Mr. Ng said just now, this will be looked at. As for the issue of caseload, I hope members can understand this. Even though there has been a drop in caseload, when I answered Mr. Porche's question just now, the complexity of cases have actually increased. So that's why these cases have been taking longer time. According to my record, Mr. Wong Yuk-man and Mr. Ronnie Tong would like to ask first round questions. I have to draw a line here, and for second round, Mr. Dennis Kwok. So for the second round, 3 minutes. Members, no more first round questions, right? I'll draw a line here. Mr. Wong Yuk-man, Madam Chair. In 2008, the CE in Council decided on a new mechanism for judicial remuneration, and there is a basket of factors, for example, judicial independence, and there are 12 factors highlighted here in the paper. So these are basic principles. I do not object to them. Now, for the Judicial Committee members, they are all rich and powerful people, and there's no body representing the views of the people, and the CE is not elected by us. So that's why there are so many problems. And now you are saying that the principle of judicial independence would have to be upheld. And the Judicial Committee will do that. And that would be the premise of judicial remuneration review, so as to ensure that the judicial pay will be able to attract talents, so that judicial independence can be upheld in Hong Kong. So if judicial independence is to be upheld, that has to be embodied in judicial remuneration. I think this is really problematic. Now you are suggesting an increase by 5.66%, and it will take effect from the 1st of April onwards. So this is again about the old age living allowance. That is about backdating. Now you are proposing backdating back to the 1st of April. And for the old age living allowance, you're saying that if you do not approve it today, then it cannot be backdated to the 1st of October. Why is this so strange? You are bullying the elderly. So now for the judges, you say that the pay increase can be backdated to the 1st of April. So when you compare this to the old age living allowance, Mr. Matthew Chang says that if this proposal cannot be approved in October, then the elderly will be losing a month's money. And for the increase, it's 5.66%, and it's much higher than the underlying consumer price inflation. And it was forecast to be 4%, so that's 1.66% higher. And for the Statutory Minimum Wage Commission is suggesting that the minimum wage should be increased from $28 to $30. And the increase is 7.1%, but it's done once in 2 years. So it's less than 3.55% a year. So for statutory minimum wage, 3.55% annually. And now you are talking about 5.66%. And for this increase, on the 13th of July 2012, the LegCo approved a pay rise for the high-ranking civil servants. That's 5.26%. Now, of course, the judicial remuneration is unpacked from that of the civil service, but you can take reference from it. In the Judicial Committee's report, it has made reference to other Commonwealth countries' pay arrangements, and there's no change in the past year. And when they conducted their reviews, they have been very prudent. For example, they took actions such as pay freeze, deferral of pay adjustment, or pay rise at lower rates as compared to the previous year. So according to this report, for this pay increase is different from other common law jurisdictions. So I suggest that you make a comparison with other common law jurisdictions. And the director said just now that she may have the information, and that can be provided to us later. And also the judiciary says that it would not accept any arrangements if the judicial remuneration is to go down. Now, if you look at the basket of factors, what if our economy goes wrong? And how about the external economy? What if there are fluctuations? And what if Hong Kong's economic situation is impacted on? So you really have to look at these factors. So for the JJOs, their pays can only go up. They can never go down. Otherwise, there will not be judicial independence in Hong Kong. And if Hong Kong's judicial independence is being attacked, it's not because of their pays, it's because of other reasons. For Mr. Wong's questions concerning the Judicial Committee members, there are experienced legal practitioners, including Mr. Yu Hoi and Mr. Wong Ka-shen. Well, they are the rich and powerful in our society. They are people with vested interests. And also for 5.66%, why is that higher than the civil service pay rise? Well, because the two mechanisms are different. For 5.66, we have taken reference from the upper band of the private sector pay trend, and also we have deducted the in-scale increment from that.
Mr. Wong Yok-man asked whether there would only be upward adjustments and no downward adjustments. Now, we have to respect the views of the judicial sector. In 2010, when the administration experienced a salary reduction of 5.38%, the salaries of JJOs were frozen. And then when we had a pay rise of 1.6%, the salaries of the JJOs were also frozen. And then 2 years afterwards, when civil servants had a pay rise of 7.34%, JJOs only got 4.22%. So I can only say that we have an independent adjustment mechanism for JJOs. Yes, the two mechanisms are different, but every time a basket of factors are looked into. Mr. Ronnie Tong, Madam Chairman, it's just like councillors. No matter how much salary you give the judges, some people just don't want to do it. Is it difficult to recruit judges? I don't think so. At least recently, 2 young, senior, competent barristers were willing to serve as judges. So I don't think we need to solicit help from overseas. I also agree with Mr. Paul there that the era of overseas lawyers coming to Hong Kong to serve as judges is over. Locally, we have enough talents to fill the judicial posts. As for the long waiting time, one reason is the retirement of judges. Another reason is that we now see more individual litigants. Can Ms. Choi give us some information about the non-represented litigants? Do we have an increase in that type of cases? These cases are longer because for a one-day hearing, it can be prolonged to 2 or 3 days for non-represented litigants because judges have to spend more time to explain a lot more details to them. And this is because our legal aid system is totally detached from society. And barristers have monopolized the market. I hope that after the enactment of the competition ordinance, the first sector to be reviewed may be the legal profession. We have to examine whether or not there are a lot of anti-competition elements in the legal profession. And Ms. Choi, we should see how we can reduce the number of cases involving unrepresented litigants. I think that's one of the major causes. Ms. Choi, sorry, Madam Chairman, here I don't have the information about unrepresented litigants. Well, maybe you can give us a written reply. Yes, I think Mr. Ronnie Tong's question is also the question of many other members. And what about the waiting time for cases with unrepresented litigants? All right, we have the second round of questions. Mr. Dennis Kwok. Well, thank you, Madam Chairman. A simple follow-up. The Judiciary Administration was asked whether or not the judiciary was given sufficient resources. We can see a reduction in cases. And Ms. Choi told us that the degree of complicatedness of cases has been enhanced. We have to see whether or not that's true. What about the High Court? Is the average handling time and hearing time longer on the average? Is it because of a rising number of cases involving unrepresented litigants? Because for cases involving unrepresented litigants, the hearing time is usually lengthened by a third. And 30 to 40% of civil cases now involve unrepresented litigants. That's a high figure, and the legal profession has always been very concerned about that. I would like to invite the Judiciary Administrator to explain to us whether or not the judiciary has sufficient resources in this sense. I hope that they can submit a report to us as soon as possible such that we can ask more questions about that. I think we need to follow up on this issue. Ms. Choi, any supplement? Well, I think we're all very clear about this issue. First of all, members would like to know the waiting time, and the public would like to know as well. And secondly, how we compare with other common law jurisdictions in terms of salaries for JJOs. Thirdly, we would like to know more about the cases involving unrepresented litigants. So please give us more details. Now here, I'd like to consult you on the administration's proposal, that is, to effect a pay rise of 5.66% for JJOs for 2012-13. Any objection? If not, we agree that the administration can submit this proposal to the Finance Committee. I agree, but then I hope that when they go to the Finance Committee, they can include in their papers their answers for today's questions. Then we don't need to ask the questions again. And for those information outstanding, I'd like to have them included in that paper as well. Now let's proceed to the next item on the agenda. Please invite the officials to come in first. The second item on the agenda is related to paper CB bracket 461/1213 bracket 02. That's about the proposed creation of a supernumerary post of Deputy Principal Government Counsel in the Prosecutions Division of the Department of Justice. So it's paper CB 61 bracket 02. We'll first of all invite the representatives of the Department of Justice to introduce the paper to us. Thank you, Madam Chairman. I'll briefly introduce our proposal to you. In our paper, we propose to create one supernumerary Deputy Principal Government Counsel, DPGC post in the Office of the Director of Public Prosecutions. And the post will last from the 18th of December 2012 to the 30th of September 2017 to handle a substantial corruption case at the moment. At present, we have 4 divisions comprising 17 specialist sections, each focusing on a specialty and to provide criminal advice and carry out advocacy work. 15 of the 17 specialist sections are headed by an Assistant Principal Government Counsel. As I said, each is responsible for specific areas of criminal advisory and advocacy work. For this substantial corruption case, is very complicated, and different defendants have appointed different senior counsels and counsels to represent them. We envisage that given the complication of the case and the possible time required for appeal, the whole case may last for a long time, and we need a dedicated colleague to be responsible for the case. We did consider internal deployment, but be it in the in the prosecution division or other division, our colleagues are already overburdened with work, so they cannot carry out extra duties. So in order to do preparation and coordination well, we need a dedicated post for this particular case. In order to cope with this case, we've already made some provisional arrangements. With the approval of the Civil Service Bureau, we've already made use of our delegated authority to create a post of Assistant Principal Government or a Deputy PGC post up to the 17th of this month. In terms of workload, preparation work, and the degree of complexity of the case, we propose that after the expiry of this 6-month post, the post can be extended to the 30th of September 2017. As for supporting staff, a senior government counsel and a government counsel will be assisting this colleague in terms of preparation and other tasks in future. And those two posts will expire on the 30th of September 2017. Of course, if we can complete this case earlier, then the posts will no longer be required. Questions are welcome from members. Thank you, Mr. Ho. Does any member wish to speak? I'll accord 5 minutes to each member. Mr. Wong Yok Man, Ms. Emily Lau, and Mr. Ronnie Tong would like to speak, and also Mr. Dennis Kwok. Mr. Wong Yok Man. Madam Chairman. Well, this post is to be created to handle a big tiger, so to speak. But then a great deal of money will be involved. That's number one. Well, of course, this will be a major case. I believe this will be the biggest corruption case ever since the handover. The defendants involve a former CS4 administration and 3 tycoons. Well, it's meaningless to deal with the details of this case here. But then for this supernumerary post, you have to be very careful. You cannot let people suspect that you've already got somebody in mind, or you're creating this post for the sake of that person. You must not give people this bad impression. So please explain to us the normal procedures and recruitment criteria for such a supernumerary post. And is the proposed practice the same as before? Will the candidate be internally promoted or recruited externally? So I believe the administration has to give us some concrete explanation. Besides, I agree that the trial of this case will be very long. This supernumerary post will expire on the 30th of September 2017, and we're now only in 2012, so you're talking about a few years. With so many senior counsels here, I must not pretend to be an expert. Now, what if the case is concluded very expeditiously? Will this person be receiving salary until the 30th of September 2017? Mr. Ho, you have to explain this to us. Well, very clearly, this post is to be created for this major case. Another query is, you say that because of this case, the DOJ will be very busy and heavily burdened, so you need this post. What about the ICAC? Well, on this particular case, the ICAC will have to do a great deal of work as well. So, is it that the ICAC can also ask for additional posts? You're asking for a supernumerary post that is to last 4 to 5 years. And half a year is to be done under delegated authority. Paragraph 4 of the paper mentions 2 other posts, but they're not supernumerary. Well, please do some calculation. For these 3 posts, we need to pay $50 million more every year, excluding money spent on outsourced lawyers. Well, we should spend what has to be spent. But we're the government. I don't think anybody will have dissenting views on creating a post for this particular case. But we're concerned about how you're going to recruit the person to fill the post. And you're spending so much money on this case. Well, you have to be very prudent on the spending of public money. And now the government is trying to make councillors scapegoats or sinners. For the proposed new OAA, means test is to be conducted even for elders at the age of 70, and then you're forcing us to pose as sinners. You said that our concerns were irrelevant, but in fact our concerns are relevant because you're spending public money. So I hope that the administration can answer these few questions of mine.
Mr. Ho? Yes, we agree that the government has to be prudent when it comes to using our resources. So we have been very prudent when it comes to the creation of posts, and we have looked at the time limits, etc. And as I said just now, the workload is very heavy and it's a very complex case. So in order to handle this case properly, we need a person to head this dedicated team. So we will follow the normal government procedures, and this post will be taken up by civil servants. We will not be recruiting from the private sector. And this is a supernumerary post, and we will identify a person with, well, at the moment we already have a person who's doing this job, but it's a temporary post. Each year we'll take a look again in this position and try to find out whether there's a more suitable person for this position. So each year we will have this internal procedure. That is, these person on the post will be compared with other colleagues and try to find out the best candidates for this post. So this will be an open procedure, and members of the department will all know what's going on. Well, how can you say this is open? They are all civil servants, and each year you will conduct a review. So this post is not to be taken up by a specified person. It's not the same person every year, and it has to head that dedicated team for the case. I find it very strange. So this person will have to handle this particular case, and each year you will conduct a review, and this position may be taken up by another person. Is there such a possibility, Mr. Ho? As Mr. Wong said just now, what if this person that's taking up the post is not a suitable candidate? So each year we will conduct a review, and we will look at the experiences and the performances of our colleagues. So if this person that's taken up the post, if he has a good performance, then actually, and of course it would remain in the post. Now a colleague of ours is already taking up the temporary post, and we have the confidence that he can do the job well. But formalities are very important, so we have to, because we have to ensure that everything is in line with the government recruitment procedures. Well, you haven't answered my question. So you already have a person in mind? So you have identified a person, and now you're just seeking the funding for creating this supernumerary post, right? So you already have a candidate in mind because the time is, because this is quite urgent. Mr. Ho? Since June this year, a temporary position has been created. So a colleague is now already in that post. Well, why can't you tell me the name? Well, I can ask Mr. Wong to tell you the name. Why is it not in the information you provided to us? I already knew that. You have a person in mind already. Mr. Ho, will your colleague tell us the name? Well, maybe Mr. Wong can tell you more about that candidate. Now we already have a Directorate 1 colleague who's acting in this position, and he's responsible for this case. He's working in our prosecutions division. He's very experienced, and we think he has the caliber to take up this post. And it is intended that he will continue to handle this case. Internally, we have a mechanism which will decide as to which colleague will take up what job. So we will look at the experiences and expertise of our colleagues when it comes to such deployments. Now there is a colleague that's acting in this D2 post already. So you should have told me earlier that a person is already acting in that capacity. Now you just want the funding. Actually, you don't need to come to the LegCo. You just come here as a routine. Now you have got yourself into troubles because you have to come to the AJLS panel and you have to go to the SC and then the FC. Well, everything's been done already. That person is already in that position and it has already been paid. Now I'm asking you and you only give me the answer. So what do you think we are? We are a rubber stamp in your eyes, right? Is it your past practice? I think this is obviously different from the past practice. I think Mr. Wong Yongman has another question about that's about a 5-year appointments. So what if the case ends earlier? What will happen to the 5-year term? Well, before I answer the question concerning 5 years, actually in paragraph 7, we have already told you that there is this temporary post from 18th June to 17th December, and a colleague of ours is already taking up the post. We have not named this person in our papers. This is our usual practice. I have read your papers, but you didn't make yourself clear because I cannot relate this temporary position to the new supernumerary post. Now, you should tell me that this person is acting and in the future he will be taking up this supernumerary post. Then this will be clear. Otherwise, it's like that. You have to answer my questions before I know what the truth is. Now, no matter who takes up that post, it would not affect on the LegCo's decision as to whether funding will be approved. Well, we have provided enough information in the paper. As for the term of employment, now because this case is a very complex one, and after the court hands down a ruling, there may still be appeals. So it will take a very long time. So for cases as complex as this, it will take a pretty long time. But in case the case ends earlier, then the post will not continue because the creation of this post is for this case. So if the case ends, the post will also end. Ms. Li Lau. So members, please try to follow the 5-minute rule. Ms. Li Lau. Madam Chair, I have received an anonymous letter. It's from a group of citizens who are concerned about this case. They do not support that this position be given to that Madam Ho. Well, actually, this letter is directed against today's paper. They think that this is just a decoy so that the D of J can expand. Well, just now in paragraph 7, you told us that a person is already acting in his position. So if we approve the funding, then that person will work in that position for another 5 years. So now she's in D1, but the new position would be pitched at D2. So if a D1 officer can already do the job, then she can continue to do it. Now, why do you want to create a D2 post so that she can get promoted? So if a D2 officer is acting, I can understand it, but now I don't think you can explain yourself. And also for paragraph 8 and footnote 1, is it the government's practice? That is for all prosecutions, the Director of Public Prosecution would make the decisions. So I think this is actually a good way of doing things. Actually, I have another question concerning paragraph 10. It says that the dedicated team, it talks about the dedicated team, and it says that it will be responsible for the case, and it would also play a leading role in the Hong Kong SALG in taking forward this case. So how is that done? I can answer the first two questions, and then Mr. Wong will answer the third question. Well, should a D1 or D2 officer be taking up the post? Now we will have to look at the complexity of the work, the sensitivity of the issues involved, and then we will look at all the relevant factors before deciding on the level. So for a substantial case, usually the responsible officer would be a DL2 officer or even a DL3 officer. And for simpler cases, maybe a DL1 or a non-directorate officer can be the head. So we will have to look at the complexity, the sensitivity, etc. of a case. And after looking at this case, we think that a DL2 officer should take up the case. So after deciding on that, we would look at our colleagues who has that experience, who has that expertise. Now, if a DL2 officer can take up that post, of course, it would be done like that. However, when we look at our colleagues this time, for our colleagues that's acting in that position right now, she's quite experienced and she has handled many big cases. So we think that she has the ability to be doing this DL2 job. So after creating the supernumerary post, she will take up the job. But as I said just now, every year we will review our vacancies and we will decide whether she's still appropriate. It's still appropriate for her to do that job, or there are other more suitable candidates. As for the second question, it's about a footnote. For this case, because it's a more sensitive case and the public is very concerned about it. So the former Secretary for Justice, he made a decision because he's one of the political appointees, and he thought that the prosecution decisions should be given to the Director of Public Prosecutions. And if there is a need, external legal advice should be obtained from senior counsel so as to ensure justice and equality.
And the new Secretary for Justice agrees to that approach. The DPP will look at all the evidence and seek external legal advice. And as a result, we're proposing this arrangement. As regards paragraph 10, I'll defer to Mr. Wong. As to how this colleague is to lead the SALG in taking this case forward, we're of course talking about colleagues in the DOJ, and the relevant law enforcement bodies will be headed by their respective heads of department. The DPP will examine issues like whether or not certain documents can be disclosed and so forth. That area of work will be taken up by the DOJ. And the legal officers of the DOJ will issue instructions to the law enforcement departments. That's what we meant by the leading role. Well, so that person won't have huge powers. Now, this person should follow the path of promotion internally. But for this proposal, we should understand it as a means for this colleague to be promoted, right? Well, I have to state very clearly here that we're not creating this post for the sake of this colleague. We create posts purely on the basis of need. Well, sometimes our colleagues have been acting in certain posts, and our major consideration is that this colleague is competent and experienced enough to fill the post. Well, the document mentioned just now is being photocopied, so I'll give the floor to Mr. Ronnie Tong first. Madam Chairman, I suggest that you grasp the time better for this meeting. For some colleagues, you've allowed them to speak for over 10 minutes, and for others, you restrict the speaking time to 5 minutes. I think once the 5-minute time limit is reached, you should ask the colleague to wait for a second round. Now, I'd like to have a clearer explanation from the administration about these 3 posts. First of all, the DPGC, and then Senior Government Council and Government Council. Am I correct to understand that you are creating 3 posts? Well, Madam Chairman, we're creating 3 posts, but one needs the approval of the LegCo. Well, let's set aside whether or not you need LegCo approval. You're creating 3 posts. In paragraph 7, you're saying that 2 of your colleagues are acting in 2 posts, and now you're asking for LegCo's approval for this particular post, and at present a person is already acting in the post. Well, that's only a temporary post which will expire on the 17th of December this year. Well, I think our colleagues are very concerned that you are actually coming here to seek our approval to increase the salary of this officer. So it's a de facto pay rise for that colleague, right? No. Well, we already have this DL2 post, and this colleague is receiving acting pay when acting in that post. Now, if this colleague is to continue in that post, he will receive a salary that is similar to an acting pay. Well, you're going to have open recruitment. You're not going to let this officer fill the post directly. Well, this post will be filled by a civil servant, so it's not necessary to have an open recruitment because it is more appropriate for a civil servant to fill the post. Given LegCo's approval, this colleague will continue to act in the post after December. Then in about the middle of next year, usually we'll have a promotion exercise in the middle of the year. Then we'll consider whether that colleague is still competent to act in that post. If there are other better colleagues, then other colleagues may also act in the post. Chairman, I think the government has to be frank with us here. He's saying that by the middle of next year, when this officer has been acting for almost a year, I really can't see how another person with no knowledge of the case can take over from the incumbent officer. So the incumbent officer will be the only choice. So you're coming here actually to seek a de facto pay rise for that officer. So our colleagues, our members here have reservation over this. If you tell us that this case is too complicated, we need to have an additional post, and we need to conduct an open recruitment to recruit a candidate from outside to join the government, I can understand that, I can agree with you. But given what you said, frankly speaking, I have some reservation. Well, Chairman, I've made myself very clear. No, you didn't make yourself clear enough. The procedures this time are the same as before. In the past, we had to come to LegCo to seek approval as well. But because of the recess of the LegCo, we could not wait, so we resorted to the usual practice of creating a supernumerary post or a temporary post. As the temporary post has been created, we must have a colleague to fill it, so we follow the existing practice to identify an experienced colleague to temporarily fill the post. As I said, in the short term, this colleague will continue to act in the post. And then when it comes to a recruitment exercise, we'll see who will be competent to fill the post. Mr. Tong may be correct in saying that the incumbent colleague has a competitive edge over his counterparts in the department. But then apart from experience, we have to look at other factors as well. We have to ensure that the mechanism is fair and that the procedures are the same as before for recruitment. Mr. Dennis Kwok, Mr. Michael Chen and Mr. Leung Pok Hong will be speaking for a first round. Perhaps I should explain to Mr. Ronnie Tong that if very few people are queuing up, I'll be more lenient. But then if we have a tight schedule, then I'll stick to the 5-minute rule. In the first round, 3 members raised their hand. Now, Mr. Dennis Kwok and 2 others have raised their hand for a second round. Madam Chairman, I have a few follow-up questions. Just now, some colleagues expressed some views about this annual salary of $1.7 million. I'd like to know, with this sum of money, can you recruit a person from outside the government with equivalent experience, knowledge, and expertise as the incumbent officer, or are you going to tell me that this sum is already too low or too small? Secondly, for this complicated commercial case, continuity of the lawyers involved is very important. For such a case, there will be many documents. And the controversy itself may also be very complex. So if the continuity is broken with the entrance of new colleagues, then the reading in time will be very long. So maybe you can explain that continuity is very important, such that the colleague can continuously monitor the development of the case. And at present, the waiting time for listing is long. Same for criminal cases. And for this case, it's very likely that there will be an appeal. So a time frame of 3 to 4 years is a correct estimation. Is it because of these factors, coupled with the complexity of the case, that you are proposing the creation of a post to handle the case? Mr. Ho? I'll answer the first question first, and then I'll defer to my colleague for the second question because he is more familiar with the private sector. Yes, for continuity, the case is complex and important, so any person filling the post will need some time to get familiarized with the case. With LegCo's approval for this post, the incumbent colleague will continue in the post for quite some time. The colleague's performance and the performance of other colleagues will be considered. If this colleague is able, competent, and experienced to handle the case, well, usually the acting colleague will continue with the acting appointment. Anyway, we'll have to review the performance of this colleague fairly. And if necessary, our mechanisms do allow for another colleague to fill the post. Now, this task is very important. If there's to be redeployment, as Mr. Kwok said, we have to consider the reading in time required. Now, we'll make our decision on the basis of existing mechanisms. I'll defer to Mr. Wong for the remaining question. Well, usually for the DOJ, particularly for prosecution cases, if we need a colleague to fill a post full-time, then to fill the post by a civil servant will incur less expenses than recruiting somebody from outside the government. We have to consider the fringe benefits, the salaries, and other on-costs. Now let's look at a DL2 colleague. Normally, a colleague reaching that rank will have 10 years of working experience, and the acting colleague does have far more than 10 years of experience. And in court, for solicitors, a solicitor with over 10 years of experience can charge up to $4,000 per hour when it comes to taxing in court. So our proposal now can save a lot of resources for taxpayers. Mr. Leung Kai-Cheung has raised his hand. I'll draw a line there. Ms. Emily Lau, second round for you, 3 minutes, and then Mr. Michael Tan. Thank you, Madam Chairman. I just want to ask a few simple questions. Number one, to create a post just for a case and to last for 5 years, has there been any precedent in Hong Kong? If there's no precedent, then this case must be unprecedented in terms of complexity and workload. That leads to my second question. If the defendants can commission world-class lawyers from around the world to fight the case for themselves, then given the equality in front of law, what about justice? If you have this added post for this dedicated case, my assumption is that your chance of winning the case will be higher. So theoretically, you should do the same for other cases. Well, unless the defendant cannot afford hiring lawyers. But given the rapid development of world economy, I can expect more major cases to come. So can you tell me whether this will be a once and for all case? Will there be a similar situation in future? Mr. Tian mentioned justice and fairness. That's very important. In the DOJ, when we handle major cases, we have to consider the complexity and workload of the case concerned. And we do have dedicated posts and dedicated colleagues to handle such cases. We've all along been doing that. I believe that in future, when handling important cases, we'll again have dedicated colleagues to handle them. Perhaps Mr. Wong can brief you on our past practice.
No matter whether it's the provision of legal advice or advocacy work, well, actually for advocacy work, it involves both criminal and civil cases. When it comes to the deployment of work, of course, we have to look at the complexity of the case, how much effort is needed, how difficult the case is, and the experiences and abilities of our colleagues. So for the DOJ, no matter whether it's advisory or advocacy work, no matter whether it's criminal or civil, sometimes we need to identify a special talent for that job. And the DOJ, to a great extent, has flexibility. For example, we can hire external counsels and we can do internal deployment. And in the past, as well as in the future, no matter whether it's civil or criminal cases, and also we will not rule out the possibility that there will be fiat counsels, or internally we can deploy our own counsels, or we can allocate more resources so that we can seek other assistance. I think you have misunderstood my question. I don't care who's taking up the job, whether it's internal deployments or whether it's a fiat counsel. Now you are going to create a supernumerary post for 5 years, and you are coming to LegCo for money. Has there been a precedent like this in Hong Kong? Well, in our department, through internal deployment, we created a supernumerary post for a colleague, and he was responsible for one case or several cases. There are some examples. Do you seek funding from LegCo? That's my question. No, there was no need at that time. So you have never come to the LegCo to ask for money so that you can create a post for several years in order to handle one single case, right? The answer is no. Please answer my second question. How about fairness and justice? In the future, if a defendant can afford such a huge team of counsels, will you do the same thing, that is, create another supernumerary post? Now, we will look at the case. We will look at its complexity, and we will try to find out whether there's such a need. If there is a need, then if we have the resources, of course, there will be internal deployment of resources. But if we do not have that particular talent, then maybe if we do not have enough resources, then we may need to apply for extra resources. Well, in early years, for government departments, when it comes to making use of resources and to create new posts, actually it's much more flexible. But then there was this arrangement, that is, for creation of posts, we have to come to the LegCo for funding. I knew that in the past, the Department of Justice had employed outside counsels to do certain jobs, but at that time we didn't need to come to LegCo for funding. But now the times have changed. If we are creating a post for more than 6 months, then we have to come to LegCo for funding. Well, in the past, the practice was different, and now, due to the present arrangements, we have to come to LegCo to make this application. Now, two more members have raised their questions, Mr. Chung Kwok-pen and Ms. Claudia Mo. Just now, I drew a line after Mr. Leung Kai-chiang, so I would allow time for these two members to ask questions, but 3 minutes only. I can only extend the meeting by 15 minutes, but as you all know, at 6:45 there will be an FC meeting. So I hope that we can end this meeting by 6:40 so that we can hand over this venue to that meeting. So for those members after the line, you only have 3 minutes. Mr. Leung Kwok-hong, Madam Chair, what's the consequence of giving them money? Mr. Ho, do you have a plan B if you do not get the funding? Well, you must have a plan B, because the funding won't necessarily be approved. Well, of course, we hope that the LegCo will approve the funding. But if we cannot get the funding, well, this is not just about money, because when it comes to the creation of posts like this, we have to get the approval of the LegCo. So even though if we have the money, we need the approval from the LegCo. Well, as members would understand this is a substantial corruption case, so we really need that post. But if it's not approved, then of course we have to find other ways. For example, should we be forking out more money so that we can find an external counsel, but that actually would cost more. Yes, I understand. But if there is not such a supernumerary post, and then you cannot assign a colleague to look at this case. Or how about 3 officers? Maybe 3 officers can take up this case. Why not? I've been listening to you very carefully. You said that in the past. That has been the approach. But now we are in a new era, and we have to approve the funding. Now you are giving us a problem. So if you cannot explain to me why you have to create this supernumerary post, it's very difficult for me to approve the funding. Well, it seems that you are blackmailing us. That is, if we do not approve the funding, you will have to spend more. Well, I'm really startled by that. That is, if I do not approve the funding, then you really would have to pay more. Then, if that is the case, then actually we do not have to foot the bill, right? Well, I have to clarify. Of course, I'm not trying to blackmail you. Well, let me explain myself. Actually, it has been explained in the papers. That is about other options. Now, we can consider this. That is, internally, well, the work can be shared by different officers, and I've explained in the paper. And actually, our workload is already very heavy now. And in the prosecution division, we have looked at our work. Our officers all have their hands full. And as Mr. Leung pointed out just now, yes, we do have many officers, but we do not have 3 officers who have enough time to handle this big case. And if this case is shared among different officers, it's not appropriate, because this is a very important case and it's very complex. So we need a designated officer to look after this. Mr. Leung Kwok Hong and Mr. Leung Kai-chang can both enjoy 5 minutes. Yes, I know it's complex. That is, whether certain things should be disclosed, and if too many officers are involved, there will be problems, right? If we do not handle the case properly, or if we are not well prepared, then the hearings may be influenced. So we really have to be careful. Okay, let me bargain with you. So if it's a supernumerary post, it has to be pitched at the D2 level. And we have to give you the funding for creating such a post. That is a D2 post. Is that what you mean? Well, it is because these posts would have to handle very complex issues. I said just now that for even more difficult cases, we need a D3 officer to handle that. Well, I don't think expensive barristers would definitely win a case. Well, but don't tell me this. If a person is ranked higher, then his performance will be better. I've seen many cases contrary to this. For example, Mr. Stephen Lam. Any supplements from Mr. Ho? Well, Madam Chair, we really have looked at the nature and complexity of the job, and then we decide on the rank. Well, because for some cases, the responsible officer may be DL2 officer, and some are DL1, and some are non-directorate officers. So for this case, a DL2 officer would be most suitable. Mr. Leung Kai-chang. Madam Chair. Mr. Ho. For the prosecution division officers, do they have to fill out time sheets? Because you say that they are very busy. So for the past 12 months, how busy were they? Because in the commercial sector, you really need this kind of data. Just now, Mr. Ronnie Tong talked about paragraph 14, and here you talked about 3 posts, and for 1 post, you have to get our approval. That is DPGC, and also you have a senior counsel and a senior government counsel and a government counsel post. So for these 3 posts, they are in the same package. The 3 of them would be responsible for this case solely, right? So if they make the calculation, if each person works for 2,000 hours a day, then for 5 years, that would be 30,000 working hours. So do you think 30,000 hours would be too much for this case? And I hope that later on you will give me a paper on the Kerry case. Well, that was also a very complicated case. And how many officers were designated for that case? And how many man-hours were spent on that? I can answer some of these questions and Mr. Wong can supplement. Now, for the package you mentioned, now we need to create 3 posts in total. That includes 1 DJGC, 1 SGC, and 1 GC. We have looked at the workload of the prosecution division, and we have conducted a review. For example, the legal advice, the officers would have to give the number of days that they have to appear in court, etc. And after that, we find that we do not have extra manpower. As for the Kerry case, I can provide you with more information after the meeting. Mr. Wong? In the Department of Justice, and we have looked at the work of government councils. Actually, the work is quite different from the private sector. We do not use time sheet. We look at the number of days that they have to appear in court, the legal advice they have to give, and the time they spend on preparing for cases. We have looked at our internal figures concerning different jobs and different departments. In general, for the past few years, these figures have been quite stable. So this is a very special and substantial case, and it's very complex. And if we take the appeal time into account, this case may take up to 5 years. So we think there is a need to have 3 full-time officers so that this case can be handled. We have looked at the number of defendants in this case and the barrister and solicitor teams hired by these defendants, and then we have made a comparison.
As for past cases, in the Kerry case, as well as ancillary prosecutions and so-called satellite litigations, we needed a DL2 colleague to lead the team. So that did happen in the past. For civil cases, for the right of abode case, we did need a DL2 colleague to lead a small team to handle several test cases or indicative cases from the court of first instance up to the court of final appeal. This is to address colleagues or members' concern about whether or not we need a DL2 post. Well, we have a tight schedule. I'll give the floor to Mr. Chung Kwok Pan and Ms. Claudia Mo. I'd also like to know more about the Carey case. It's also a very complicated case, which was completed after more than 10 years of work. Mr. Michael Tian asked for precedence, and just now the DOJ told us that a DL2 post was required to lead those two complicated cases, that is the Carey case and the right of a boat case. But for those two cases, the DOJ did not ask for the creation of a DL2 post. So why is it that this time we need this dedicated new post? Mr. Wong, I was about to come to this aspect. Yes, indeed. At that time, we required a DL2 post to lead the team. And at that time, we filled the post with an incumbent colleague. As Mr. Ho explained, the system then was different from what we have now. And at that time, there were internal resources within the department to do deployment. And so we did not require approval from LegCo. Again, at that time, for a certain period, a colleague was acting in that DL2 post. Mr. Chung Kwok Pan, well, you said that the system was different then. Can you tell us the difference? You also told us that at that time there were internal departmental resources for the post. So why? Mr. Wong, as far as I understand, about a decade ago, we had divisions with interdeployment. And so the divisions together applied for a post to LegCo. Let me cite the prosecution's division as an example. It has a different number of directorate posts than other divisions. So if the division itself no longer has additional manpower resources for the new post, then we'll have to create a new post. Ms. Claudia Mo, well, just now you said that this is a precedent. This is the first time you come to LegCo to seek approval for the creation of a dedicated post and basically for a dedicated person. And that post will last for 5 years. You said that basically this was not done in the past because in the past the administration had greater powers and it did not have to come to LegCo for approval. I'm worried that you are creating a dangerous precedent. In future, for other cases, you may also tell the LegCo that you need a stronger person to lead the team. Another way of putting it is that you really want to convict the defendants this time. That's why you're asking for additional resources. I really cannot see that this is an unprecedented case with unprecedented complexity. You must support your statement with evidence. The Carey case was an extraterritorial case to a certain extent. It involved multinational facets, and at that time I was a journalist, so I'm very clear about that case. Well, Mr. Ho, well, we do need a dedicated person to handle this case. Well, there are different ways to go about it. We can do it by way of internal deployment. Now, just like the Kerry case, we need a dedicated post for this particular case as well. Back then, a dedicated colleague was assigned to that case. But at that time, that colleague served as an advisor. So the government was actually employing something like consultancy service. So the government did not have to come to LegCo for approval. Now, this time, we consider that the post should be filled by a civil servant. That's why we have to follow the existing procedures by coming to LegCo for approval. Can you give me a precedent in terms of complexity? Can you give me a similar case in the past in terms of complexity? Well, Mr. Wong is more experienced in this. Well, please be concise. We have to take a vote. Well, Ms. Mo asked whether future cases were handled similarly. Well, if for a future case a dedicated post is needed, we'll adopt similar procedures. Well, Mr. Wong can say something about precedents. In terms of corruption cases, this case is really unprecedented in terms of complexity. So he is saying that it's beyond comparison. Yes, given the complexity of the case and the seniority of the official or past official involved is beyond comparison. And we also know what lawyers the defendants are going to employ. All right, colleagues, we have to make a decision on this proposed creation of the DPGC post. Any objection? There's no objection. But, well, Ms. Emily Lau, well, if they want to go to the establishment subcommittee, let them do so. But then many questions remained unanswered. As for the anonymous submission, anonymous letter, they should include their responses in their ESG paper as well. We'll let them go to ESG if they want. Well, Mr. Ho, I believe you've heard our colleagues just now. I hope that you can handle this case well. Our next meeting will be held on the 27th of November at 4:30 p.m. Thank you very much for attending this meeting. We'll follow up on items 1 and 2 on the agenda. We still have many outstanding information. Thank you.